Welcome everybody to this Quadrant webinar in partnership with Maritime London, exploring a new world order, navigating geopolitics with English law. And I think before we get started in regard to the exam question, it's useful to provide some context. As far as I can remember, in the run-up to 2020, the biggest issue the shipping industry was contending with was the implementation of the sulfur cap. Now, since 2020, and this list is not exhaustive, and I'm sure I have missed many things out, the increase in macro events, geopolitical events that the shipping industry has had to contend with, and regulatory pressure has possibly been unprecedented. We, of course, had to deal with the pandemic and the consequential pressure on supply chains, Russia's invasion of Ukraine, the Black Sea war risks, and the acceleration of unilateral sanctions regimes, and, of course, the constitution of the oil price cap. We are now experiencing Houthi attacks on merchant vessels in the Red Sea. And, of course, what can only be best described as a dynamic tariffs and counter-tariffs environment. And further, to add greater pressure, we are managing a slew of decarbonisation regulation, energy efficiency design index, the energy efficiency existing ship index, the carbon intensity index, the EU ETS, and now, of course, the IMO agreement on a global marine fuel standard and GHG emissions trading scheme. Now, throughout all of these events, the shipping industry has shown a tremendous level of resilience. But against this backdrop, we need to understand what looks like a safe harbour in regards to governing law and dispute resolution. And in this context, to discuss the advantages of English law, we've brought together an excellent panel today. So we have Nigel Cooper, KC at Quadrant Chambers, Nichola Warrender, KC also at Quadrant Chambers, Clare Ambrose, full member of the LMAA, and last but certainly not least, James Wilkes, Managing Director at Gray Page. Now, James, I think I'm going to come to you first and ask you, I suppose, operationally on the ground, what have been the key geopolitical drivers causing greater levels of uncertainty within the global shipping industry?
Good morning, Joss, and morning, everybody. I think much of the uncertainty the shipping industry has been experiencing in recent times is the consequence of second-order issues flowing predominantly from three major sets of geopolitical circumstances to which you've already alluded to, Joss. Firstly, we've got the decades-long tensions and arguments in the Middle East, in particular, Iran's posture towards the US, Israel, and the European West, and other Gulf states as well, and vice versa. How, in particular, the US and Israel are shaping up to Iran, resulting palpably for shipping in the physical threat to merchant tonnage in the Red Sea posed by the Houthis, as well as ongoing ship seizures in the Persian Gulf by the Iranian Revolutionary Guard Corps, the IRGC. Secondly, Vladimir Putin's desire to remodel Russia's place in the world, leading most recently to Russia's illegal invasion of Ukraine in 2022, but the seeds of which he was sowing when Russia invaded and then annexed the Crimea Peninsula in 2014, and then launched its military intervention in Syria in 2015, giving Russia the ability to project greater naval force in the Black Sea and then the Mediterranean. Since the spring of 2022, merchant ships and cargoes have been trapped and then abandoned in Ukraine. There remains an extant physical threat to ships still trading to Ukraine, and of course, the continuing diminution of Ukraine's major exports, especially grain. Thirdly, there is China's continued political, economic, and naval expansion, and the challenge of that to the hegemony of the Western world, but in particular the United States. So as a result of all three headline issues, we now have the largest and most complex set of sanctions regimes ever constructed, impacting on international trade, but also posing questions about freedom of navigation and the right of innocent passage. On top of that, we are now having to come to terms with the most recent shift in the tectonic plates of geopolitics, being, of course, the new administration in the White House, or new since January. To say that it has tipped over the apple cart might be an understatement. Whatever plays out in the next 4 years, the immediate impact of the administration's trade tariff strategy, its posture towards Iran and the ramping up of support for Israel, its approach to solving the war in Ukraine, its stance towards China, and the surprising stridency with which it has told European and NATO allies what it thinks of them, has been to discombobulate, disrupt, and destabilize international trade, the financial markets, and global economic forecasts, as well as questioning potentially the future of NATO's traditional security architecture. Shipping has always had to weather whatever rainstorms geopolitical uncertainty creates, and right now those rainstorms look set to intensify into a monsoon of more unknowns and greater unpredictability.
James, thank you so much for that fulsome appraisal as to where we are currently in regards to the geopolitical landscape and quite how far we've come over the past 5 years. And I think, Nichola, I'd like to come to you now in the context of this discombobulation that James highlights. How does English law provide a level of certainty against this incredibly complex trading environment we're currently working through?
Thanks, Joss. I mean, I think the first thing I'd say is that this is not a new problem. So there have been previous instances of armed conflicts, causes of disruption to shipping, and shifts in political and trade alliances in the past. So as a concept, the sort of things that James has been talking about is not really a new one for English law or English lawyers. And as a result of that, we have a fairly sophisticated English legal framework, which has been not only developed, but tested by those past geopolitical risks and events. And so, although we can't predict with any degree of certainty what exactly the new form will take, we can give some good indications of how the system can and will respond to new ones in the future. And the framework itself doesn't just seek to offer parties certainty in one way, it offers it in a variety of different ways. So if we look at it just, for example, thinking about a commercial shipping contract, one of the important features of English law is that parties are free to allocate their risks and manage them how they see fit. And there's very little statutory intervention as a matter of English law. And that allows the parties to create their own certainty, because on the whole, English law will respect and uphold their contractual bargain. And when it comes to working out what that is, English law has a fairly well-developed rules and principles as to how contracts are construed. And it's important to sort of think about the underpinnings, because one of those is that commercial parties like and value certainty, and that's one of the principles and assumptions made when the courts and arbitration tribunals are considering the proper construction of an English law contract. So it's not unusual to find where the parties can foresee a geopolitical risk, use a contractual allocation of that risk, sometimes in the form of standard form contracts, and most of those too have been developed against a framework of English law. And then over time, we have a body of precedent about how those standard forms and standard terms themselves are to be interpreted. And that can develop as the cases come before the court. So, for example, we had Con Wartime was looked at a case, and as a result, it was revised to better reflect what the industry needed to provide them with greater certainty. And obviously, it's not always possible to work out where the geopolitical risk is going to arise to be able to have the contractual allocation of risk. But there too, English law provides some doctrines which help to create some certainty. So we have doctrines such as frustration and illegality. And I'm pretty sure a lot of people now know we don't have a freestanding doctrine of force majeure, so please put that in your contract. But in terms of frustration and illegality, we've seen those come to the fore with recent geopolitical events, for example, in the Red Sea. And also we've seen the rationale of those doctrines and when and how they apply in particular contrasts being played out in recent decisions. So, for example, in the context of force majeure, and also about how sanctions affect the party's ability to pay, for example, services or goods. And we've seen quite a lot of that recently. But those themselves are not new doctrines, and there are established legal principles behind them in this body of case law that also helps give the parties some predictions, even if the fact patterns change, how the principles are likely to be applied. And I think the final thing I'd say is that we shouldn't overlook that all of these sort of legal doctrines are supported in English law by sort of evidential rules and really good, clear procedural rules, both in English courts and in the arbitration institutions, which all help give some certainty about how the legal disputes, when they do arise, are likely to be determined. So I'm not just saying it from a lawyer's perspective. I do think the industry can have some confidence that English law provides them with some certainty in what seems to be very uncertain times.
Nichola, thank you for that. And I think I'd like now just to stay a little bit on that dispute resolution piece. And when a dispute does arise, and, you know, regarding the impartiality and the ability to enforce rulings, Clare, how does London-based dispute resolution offer greater resilience than comparative jurisdictions?
Well, I think London has very strong features giving resilience, both in deciding disputes and in the enforcement of decisions. I think it's fair to say that we're top of the class in terms of impartiality and rule of law, in that the independence of the judiciary and arbitrators is undoubted. In the US now, real questions can be raised as to whether judges and law firms are subject to political pressure. I think that genuine doubts can be raised about bias in the same way they might have previously been done about some of the some totalitarian regimes. So that is a real slightly shocking development, I think. We've also seen the executive be heavy-handed in other jurisdictions like Hong Kong or Dubai, and that can be really alarming and also disruptive at a practical level for commercial parties. As an example, in Dubai, they just shut down an arbitration institution overnight, which was a joint venture between DIFC and LCIA, which had a big caseload and was operating quite successfully. So parties, blue chip parties with large disputes, were left in a temporary void. So it turns out the rule of law isn't just some slogan that you put in a brochure for an arbitration centre. It's actually an essential feature for a reliable jurisdiction. And to be frank, it turns out that governments who pour money into fancy arbitration centres may not be reliable supporters of independent and neutral dispute resolution, which I think is what commercial parties should be looking for. The UK government, unfortunately, doesn't put much funding into commercial dispute resolution. We have had some new courts, and that's been good. But what matters is it doesn't interfere in judicial and arbitral independence, and that's consistently respected by the UK state. So if I had a dispute, I certainly would prioritise that over having a fancy venue or short-term tolerance for making it easier to do business. And I suppose on that front, I think London has generally got about the right balance on sanctions, which in effect are an intervention. I mean, at the outset of the invasion of Ukraine, the UK government had to respond quickly, and they didn't get everything right. There were some hiccups. And there are still, of course, cases going to court to sort of challenge decisions made. But I think that's healthy that decisions can be challenged. Overall, the sanctions are probably a necessary evil. There are other jurisdictions which don't have sanctions, and they may, in the short term, make a quicker buck and maybe slightly easier jurisdictions to manage. But long term, they've got less legitimacy. And certainly we see weaker safeguards in other jurisdictions like Dubai or Singapore. So, but I think it's important to tell users loud and clear that London is very much open for business, even for sanctioned parties, because I think some parties have been told otherwise. And on that front, one feature I think it's important being very aware of is the UK government at the end of March granted a general license for all types of arbitration. Previously, there was a license for LCIA arbitration. And the LMAA lobbied quite hard for this general license. And it means that it's easier for a party to have its dispute decided in London, that the arbitrators can proceed in a sense knowing they'll get paid. And it also means disputes aren't frozen because of sanctions. Just a final point, in terms of enforcement, I think arbitration is better insulated than court litigation because it's more independent of the judiciary, whether it's typically in other jurisdictions. And the New York Convention on Enforcement is a very well-respected institution. There aren't many jurisdictions who are going to be brave enough to sort of start saying, oh, we're going to pull out of the New York Convention. And we haven't heard that sort of language coming out. And so I think it's a very reliable piece of law. And we saw that when Brexit came in, that arbitration was more insulated from that political uncertainty.
And just to stay with you, Claire, for a second in regards to government engagement with the dispute resolution sector. We often hear that the UK government perhaps doesn't support the legal sector as much as other jurisdictions, but there's a fine balance there, isn't there? I suppose, because if you have too much government support and engagement, then they start to project their own aspirations and objectives on the sector, and then you might lose some of that independence. Is that a fair sort of summary of the situation?
Yes, I think it's of utmost importance that the government doesn't start dictating the terms upon which courts or arbitral institutions act, that there is a separation of decision making. I do think it's good for there to be good channels of communication. So, for instance, when the sanctions came out, there was a hiccup in that one of them, it wasn't clear whether it covered trade as opposed to sort of sales, as opposed to there was a hiccup as to the scope of some of the sanctions. And in that sort of situation, it's important for people like Maritime London or the shipping sector to be able to talk to the government and be able to get through and say, hang on a minute, did you really mean this? Can you do something about it quickly? And it's good if there's good channels of communication and you're not thinking, well, do I speak to Treasury? Do I speak to Department of Transport or Ministry of Justice? So I think that sort of communication is important, but independence is also important.
And I think we all remember that hiccup very well, Claire. But again, I suppose the fact that the Treasury turned around and issued that general license to ensure that arbitrators can be rewarded for their work again shows the flexibility and engagement with government and how that can work in the UK.
Yeah, they do listen.
Perfect, Claire. Thank you so much for that. And Nigel, I'm going to come over to you now, and I think that both Nichola and James have highlighted very eloquently the raft of uncertainty that the market is having to deal with right now. And I suppose my question for you is both in regards to counterparties where a potential risk is not accommodated for, how disputes are managed in that context, but also in terms of charter parties, in terms of the drafting of charter parties. How are we managing this quickly changing environment?
Thank you, Joss. I'll come to that in a second if I may. Can I just pick up on your question to Claire? I think it's one of the examples of good communication that is perhaps worth mentioning because it feeds into the overall theme of this session, is the communication that took place in relation to the new Arbitration Act 2025, where there was a lot of consultation, where the government or the legislature eventually did take on the concerns of the arbitral community, the users, and indeed those who provide the arbitration services, and was receptive to listening to a balance. So I think I utterly endorse the notion that more could be done, that more funding could be made available to promote legal services from this country, both generally, but also in the maritime sector. But there you have an example of good communication carried through to the fact that, notwithstanding all the domestic tensions that the government has had to deal with, they did find time following the election to get the bill through. And the only question, of course, that's outstanding is when is the Act actually going to come into force, which hopefully we'll hear more about at some point soon. But going back to your question, I think there's two aspects to it. I mean, the first point is that very often, in terms of volatile risk, unpredictable risk, the question of how you deal with it in the future is not the immediate question. The immediate question, and we saw this both in terms of sanctions and in terms of events like the Red Sea and indeed the pandemic, is how do you deal with that under existing contracts, where perhaps those risks haven't been foreseen at the time of negotiation, but one has to make the existing contract work. And of course, on one level, the best way that one can make it work is there's compromise and commercial discussion between the parties to address the new situation. But that's inevitably not always going to be the case. And of course, one party is going to be saying, well, no, I have these rights under this contract, and either you perform, notwithstanding that the contracts become economically disadvantageous, or you're in breach. And of course, that situation has to be managed under the existing contract. And that's where the importance of what Nichola was talking about and what Clare was talking about comes most into play, is that you have these doctrines that can be things like force majeure, frustration, doctrines of unsafe port, doctrines of allocation of risk, all of which enable a reasonably confident view to be taken as to how an existing contract will work in an unpredictable situation. And I'll come back a little bit later to some of the mechanisms that perhaps we're going to see more of to manage that type of risk. For new contracts, for new situations, I'm not sure there are any particular changes that we're going to see to how contracts are negotiated. I mean, one has to keep in mind that it does take a long time for new approaches to drafting, for new standard forms to come through. You know, we're now on, I've forgotten which revision of it is. It might be the 2015. We're certainly beyond the 1993 NYPE, but we're still seeing lots of contracts on the 46 form. So it takes a while for standard drafting to catch up. What I do think we're seeing, notwithstanding that I don't think there's a particular change in approach, is that there's probably more pressure now on in-house legal teams, clubs, and indeed external legal advisors to provide rapid advice as to the significance of political events and their impact on parties' negotiations. And we're therefore coming back to the notion of certainty. It's important that that advice can be given against a background of precedent, a background of reasonable understanding of what is likely to follow. Of course, you do get individual actors who obviously have their own own financial best interest, their own commercial interests at heart, and therefore are going to look to be using their economic muscle to drive through changes to their contractual relationships that they want for the purposes of, in order to respond to events. But on the whole, and maybe I'm being optimistically naive about this, but I think on the whole, when it comes to these type of situations we've been seeing in recent years, particularly when you come to things like climate change and sustainability, and the need to manage emissions, there is a reasonable level of cooperation, at least at a macro level, in terms of trying to find solutions that will work for, provide at least a starting point for all parties as to how to negotiate. And so you do have not only the ordinary standard forms of contracts, but then you see organizations like BIMCO, who can produce in relatively short order standard clauses intended to assist or at least provide the introduction to negotiations. We're all familiar with the debate that took place over the CII clause. We've seen other clauses come out since. We're probably all now overly familiar with the sanctions clauses that you find, and indeed the war risk clauses. And those clauses are, again, all to be read against the background of the types of decisions and precedent that Nichola was talking about, dealing with war risk, force majeure, frustration. The Red Sea provided an example of how those clauses were quickly seen to operate in the context of what is going to happen. Our charterers able to give orders still to go through the Suez Canal, notwithstanding the risk? Can owners insist on their additional premia, and so on? Are owners entitled to say no, notwithstanding charterers' assessment of risk? We are going to deviate and go round. And all of that, I think, has been relatively reasonably managed, in the sense that I'm not aware, I mean, Clare may have a better picture, but I'm not sure that we're seeing a long tail of litigation coming out of the Red Sea. I'm not sure we'll see the same in relation to detained vessels in the Ukraine, although there is certainly some litigation arising in that context. But in terms of mechanisms we may see more of in the future, one can look to other sectors, and for example, the energy sector, where quite often you'll see in the long-term contracts clauses which allow for the adjustment of contract terms, pricing depending on changes to pricing depending on risk. And indeed, we see the same thing in the shipping sector with long-term COAs, perhaps in terms of contracts, for example, the long-term carriage of LNG to service a particular LNG project. But I do wonder whether we're going to see more growth in the use of those clauses for long-term charter parties, other forms of long-term maritime contract, as a means of managing the possible risks, which will go alongside the types of clauses that Nichola was talking about in terms of force majeure and so on. But I think one point to go back to, and it sort of, I think, underpins slightly what James was saying, is it's important not to overreact. We've all seen in the last weeks, 1 week it looks like everybody's going to be subject to ever increasing levels of tariff, and all of a sudden that's rolling back, deals are being done, and therefore it is important, and I think the market is demonstrating that now, that despite initial concerns and initial worries, there is a certain element of we just have to be more pragmatic about this and allow, not try and overreact in terms of how we negotiate our contracts. Use the mechanisms we can trust.
So I think what I'm hearing at the moment is maybe the confluence of external intervention that the industry is witnessing at the moment is unique. But if you take each of those geopolitical events, and maybe we'll talk a little bit more about the regulatory space if we have time later, but particularly in the context of the geopolitical events that we're experiencing, you take them individually, there is precedent and provision under English law, which can give the users of English law a certain level of contractual certainty. But one thing I want to investigate a bit more now is this idea of cooperation, particularly operational cooperation. James, we all will remember when piracy escalated rapidly in the Gulf of Aden, quite a few years ago now, 15, 16 years ago. Now, at that time, there was also a huge amount of industry cooperation to establish norms and best practices to deal with the novel environment the industry was having to work through. Do you think currently the industry is moving quickly enough to establish those new norms and accept ways of best practice to manage these new types of risks?
Well, I mean, it's interesting, isn't it? The industry didn't move quickly over Somali piracy until Somali piracy got really, really problematic. You know, there had been incidents starting in 2004, one or two incidents, one or two hijackings each year, and it really wasn't until sort of summer of 2008 and into 2009 that the industry started to collect its collective minds around the matter, develop what then became best management practices, maritime security against piracy. I can't remember the full long title. We just call it BMP now. So I wouldn't say that was a great example of the industry being fleet of foot. There was still a lot of debate, a lot of contention, a lot of argument about what should be done and whose responsibility it should be for doing it. But that said, there are lots of examples where shipping has been very good at pivoting to adapt to single issues, which disrupt the navigation of ships and the flow of goods internationally. We found a way to keep ships moving during the SARS coronavirus pandemic. Tonnage was rerouted away from the Suez Canal when it was closed because of the Ever Given grounding. And again, tonnage has moved away very rapidly from the Red Sea as a result of the Houthi threat to merchant ships in the region. I don't think it copes as well in response to issues that are more systemic, issues which infect a wider ecosystem. Perhaps that's because it's so big, so international, and has so many functioning parts, and every nation state seems to have an opinion about what the industry should be doing, what it should be liable for, responsible for, responding to. And ironically, because I don't think many governments understand the industry as well as they should. If you look at the Russian and Iranian sanctions regime, it seems to have thrown up more challenges than the industry can cope with or is willing to cope with. I mean, Russian oil is still being shipped in breach of the price cap. Iranian oil continues to be moved illicitly. Management services and insurance is still being provided to ships and owners when it shouldn't be. We've got ships sailing under false flags with impunity. I mean, ironically, we know the identity of the operators of the flags. We know the identity of the ships, but barring one or two individual examples, it's just not being tackled comprehensively. I appreciate that sanctions are fiendishly complex and getting more complex, but I do wonder how far the collective actions of the shipping industry have contributed to that complexity, and to an extent, the fragmentation, the natural fragmentation of an international industry prevents there being a collective systemic response.
And just staying on that, I mean, it's an interesting question, isn't it, in regards to the sanctions policy emanating out of the G7, with particular reference to the price cap. In that, of course, it's the complexity of the price cap which has almost allowed the growth of the parallel fleet, because, of course, the policy intention of the price cap was to maintain a G7 plus exposure in the trade of Russian oil. But through the development of that, actually, what it has facilitated is the ability of those outside the G7 plus to be able to ignore it entirely. And again, that creates a fragmentation within the market, which I suppose from a legal perspective adds greater levels of complexity. Is that a fair appraisal of the situation? Nichola, Nigel, perhaps I'll come to you on that question.
Yeah, I think that is, Joss. I think it's sort of almost the law of unintended consequences sometimes.
Indeed, yeah.
That they are focusing on a particular issue and they deal with it in a particular way without looking more widely and realizing actually it is a global issue. And also one has to remember that when you have EU sanctions, then it has a sort of, it does has some extraterritorial effect, but it doesn't. One of the difficulties I think that we've had with sanctions is we have one set of US sanctions, which are slightly different to the EU sanctions. And then there's another set with the UK sanctions. And even if it looks like they're cohesive, there will be a time lag in when they operate. So it's difficult enough for the lawyers. So I can only imagine how difficult that is if you are actually in the industry yourself trying to grapple with all of these different regimes. And I think we're going to see that more, not just in sanctions, but for example, climate change, all these, anything that has these sort of geopolitical sort of concepts behind them. The more that states sort of pursue their own domestic agendas and don't work together globally, the more the industry is becoming fragmented. So they might all be aligned, for example, on a particular economic position, but then you'll find the climate change position isn't the same. So I do feel for the industry, because it's not easy to grapple if you are working in a global ecosystem with all these individual state policies that are ever changing, and there's no sort of forum where there's a one cohesive policy.
I think what Nichola says about the uncertainty that individual state responses creates for the global shipping industries is on point. And we see this at the moment, in particular in relation to the climate, the work being done to control emissions. We're still at a situation where we still don't know precisely what the enforcement regimes are going to be, and whether or not there is going to be a uniform global response, or whether or not shipping companies are going to find themselves potentially dealing with different levels of control and different standards, depending in the region in which they are trading, or of course, as is often the case when in shipping, where you're trading across several different regions, and that is why the work of organisations like the IMO and the recent MEPC conference is important, to try and achieve a standardisation. What we don't yet know, of course, is whether they are going to be successful, and the importance of not only uniform but also reasonably prompt action is again emphasised by the fact that one of the hurdles, I think, to actually resolving at a contractual level how one deals with, for example, the risks associated with carbon trading in the shipping area, the risks of emissions, is that in the absence of sanctions, the level of urgency associated with resolving the contractual issues has diminished. And also, nobody knows particularly where the clauses should end up. And that does, of course, come back to the importance of work done at levels with organisations such as BIMCO in relation to the negotiation of their clauses, and the importance of a mechanism by which those clauses can be adapted so that they reflect whatever legislative or global legislative changes one has seen. What is then perhaps also important is that as those changes come through, and this goes a little bit back to what Clare was talking about at the beginning, is that where there is either an unpredictable state response or where disputes arise urgently because measures are being taken by one state that others that were not predicted, is that you can have urgent relief in the disputes world, and that you do have mechanisms available. And again, this is where there is a body of procedures available, not just from the English court system, but also from the arbitral tribunals, both in London and in other Commonwealth jurisdictions, to provide mechanisms for urgent dispute resolution, partial interim awards, injunctive relief, both from the courts or indeed from tribunals, and the increasing use of procedures such as expedited arbitration procedures and the use of emergency arbitrators, which, going back to what we were talking about the introduction of the Arbitration Act 2025, one of the steps taken there is to provide further support within English law for the mechanism of the use of emergency arbitrators.
Clare, is there anything further you'd like to add there?
Well, it's interesting about emergency arbitrators and those processes, because actually in London, there hasn't been a huge uptake in the last 2 years. I think the LCIA has had 1 or 2 cases go to emergency arbitration. I mean, that's probably a reflection that the commercial court provides quite a good service. So if you want, you can get a court-backed injunction. They're also pushing the expedited process. And certainly LMAA, we don't have a specific emergency arbitrator process because there are various downsides in terms of enforceability and whether it's better than getting a court one. But I think it is an interesting area. LMAA terms up for consideration this year, and it's certainly something that's under consideration as to whether we should have better interim relief or even emergency relief.
And I think just to build on 2 of the points that we've been discussing in sort of the second half of this, is that number one, it feels like both from a foreign policy and consequentially sanctions perspective, but also potentially and disappointingly from a decarbonisation perspective, we may be heading into a more fragmented market, possibly even a bifurcated market. And does that pose any challenges to the use or uptake of English law? I suppose and the second question there, and this goes back to Nigel's point, is one of the other things that I think we'll probably see in regards to charter parties is greater flexibility within the clauses. And does that mean that we are moving to a world of more bespoke charter parties? Or does it mean that we are moving to a world where charter party standard clauses offer more flexibility? And Nichola, maybe you'd like to comment on that.
If I can deal with your second point first.
Yes, of course, yeah.
On the sort of flexibility of clauses, I mean, I think Nigel mentioned in the energy sector, but most charter parties underlying it is a sort of commodities deal. And a lot of the commodities contracts, standard forms already have material adverse change type clauses. And we don't often see those in charter party disputes or in the standard forms of charter parties, but they have been creeping into one of the, the bespoke provisions that the parties use attached to the standard form contracts. So I do think that we might see some more of those. In terms of the standard forms themselves, I think one of the difficulties that parties sometimes have is the remedy they use to address some political risk or changing risk is to bolt on a standard clause that's been drafted with a very clear warning saying, please make sure it interrelates with all your other provisions. And then it doesn't have the effect which they intend it to have because they haven't done an audit of their existing contract to make sure that it works in the way that they want. So sometimes when you say the parties want more flexibility, if they do want more flexibility, you also have to be careful with the sort of standard form that you're working from in the beginning to make sure you don't have not only unintended consequences by the regulators imposing different regimes on you, but the way in which you do your contract themselves. So I think we are going to see more of those types of clauses. And again, I think the climate change is a good example. When at the very beginning, there were lots of bespoke provisions that we saw before BIMCO had done their sort of CII clause, where parties would set a standard for a particular term of years, but then they would renegotiate in good faith. And I think we might see those types of clauses again, if it's not a material adverse change, if the parties are aware this is a changing regulatory framework, we will set the scene now for a particular period of time and then go back and renegotiate on longer term contracts. We might even see parties changing the way in which they operate. They might decide not to enter into longer term charter parties, but to do it on a 1 year basis and then, extend it because they don't want to commit for a 10-year charter, but they want to have the flexibility to see what's happening. So, we might see that they don't enter into the 10-year charter, they enter into a 5-year, and then they have a series of addendums year on year because they think that's going to change. So in terms of the contract sphere, I can see a number of ways in which they might manage this going forward. I don't know if Nigel has any different views.
No, I don't. I think I agree with that. I suppose my comment would be, depending on the sector, there may well be trades contracts where the ability to reduce the length of the initial contract is actually more circumscribed because one needs the long-term contract in order to ensure a sufficient return to recover the capital expenditure. But I do agree that we will see the underlying point you make. I think about more flexibility. I agree, and I think we will also see, as you've pointed out, whether it's from the commodities or the energy sector, a growth in clauses that allow a flexible adaptation of the charter party, and we may all, or whichever form of contract it may be. And we may also see a greater willingness on parties to use mechanisms such as expert determination to provide a means of resolving any disagreement between the parties as to how a contract is to be adjusted, or indeed a greater willingness to use arbitration, not as a means of a final resolution of a final dispute, but actually of a means of resolving questions or conflicts that have arisen as to how a contract is to be interpreted during the lifetime of the contract. In other words, for example, if you've got a question arising under a shipbuilding or an offshore construction contract around the question of what permissible delay has accrued under the contract prior to the date for delivery, an ability to have a relatively short and quickly resolved arbitration so that the parties can have some certainty as to what their rights are around the date of delivery before a rather more serious dispute has arisen as to has the contract been repudiated because the vessel hasn't been delivered, or because one party has walked away when they don't have the time to walk away. So, I mean, I think this goes back to the underlying theme that we've been talking about, which is that on the one hand, you have a level of certainty associated with English law that is valuable, but it is also a pragmatic system of law that allows flexible resolution of potential issues.
I certainly can't see any other choice of law that would do it any better. I think English law copes with it best. It can't give certainty on every question, but I think it is a pretty sophisticated choice of law.
So just on this point, and I think, we've discussed how for the vast majority of issues, some form of precedent does exist within English law. But Nigel, you've just mentioned the pragmatism of English law, and let's just talk about this for a little bit, because whilst I totally understand the fact that we are looking at centuries of case law, and as a consequence of that, precedent is relatively easy to find in the vast majority of cases. If there isn't precedent, and if case law doesn't exist to support judgments, what's the methodology deployed in that instance? Nichola or Nigel, perhaps you'd like to respond to that.
Well, I'll step in briefly. I mean, I think the first point is that English law tends to work by looking to define principles which can be applied across situations. And therefore, it doesn't necessarily matter that the particular fact pattern hasn't arisen before. One can look at similar circumstances and draw analogy. And one of the clear examples of that does go back to the question of war risk. James has talked about Somali pirates and the response. We've spoken about the Houthis. But when you look at where do a lot of the principles that lie behind the war risks clauses, either in insurance or in charter parties, come from, they go back to earlier conflicts, Iran, Iraq, and so on. So you have that sort of ability to look across. You have the principles of contractual construction that are now well embedded in English law, and are routinely returned to in terms of working out what the contract actually means and how it might apply. And then I do think you have whether it's in terms of the arbitrators or in terms of the judges, you have a body of individuals there to do the dispute resolution who are prepared to be pragmatic. And one of the interesting examples, I think, in this relationship is, for example, in the context of crypto trading, where there are all sorts of wonderful academic discussions to be had about how do you define cryptocurrency? Is it property? Is it not property? But in the relatively small number of disputes that have come to the courts have tended to take a pragmatic approach to resolving questions like where somebody's been defrauded, how do you provide them with mechanisms by which they might somehow make a recovery, and that again is one of the elements that goes with a system of a choice of law that has a very long history in terms of commercial trading. I mean, I don't know if anybody else has any comments, or whether James has any comments from an industry perspective, to perhaps provide a different view.
I do, but not. Yeah, I'm not a lawyer, but I think anything where you've got a system that is on principles, it works on principles when it doesn't have a definitive, immediate answer to a very discrete question, then the pragmatism, the flexibility. I think, wasn't it the man on the Clapham omnibus rule? What would your average man on the street or person on the street say? Think about this. It's a good way of looking at problems, because the world's more contested, and and more complicated, and it will continue to be and get so more contested and complicated in future, certainly for the foreseeable future. That means nation states views will not align with each other because everybody's competing for fewer and fewer resources. Groups of countries are terrified that other countries are going to exploit. If they all cooperate, someone's going to win, as if it's a winner-take-all environment. And there will be countries that exploit that, and countries will act exploitatively. And so when it comes to questions like decarbonisation, or issues like decarbonisation, or when it comes to sanctions regimes, wider global maritime security, which has been discussed recently by the UN, you just won't get an alignment of views. It will more than bifurcate. It will split into 3, 4, 5, 6, 7 different main views across the globe, I think. So you can only have a principle-based approach to that, because there just isn't an answer for everything. I'm slightly concerned that industries in general just cry out for certainty, demand certainty, as if somehow certainty is a right. I think the most successful industries, the most successful businesses, and the most successful people are the ones that are comfortable operating in ambiguity, and operating in uncertainty, and those that understand the world's better viewed through the lens of probability than it is a deterministic view. And so I think, again, drawing it back to the principles-based system of English law, it tends more towards the probabilistic view then than it does to the deterministic, and that's good. That's flexible, and that's why we'd all argue that it should be the choice of forum for most contracts, most disputes in international trade, where it can be.
James, I think you've summed up the conversation incredibly well there, and I think just to add to it, I suppose the shipping industry is often an industry that thrives in uncertainty, right? And I suppose the point about English law and dispute resolution is it offers that pragmatism and flexibility to allow ship owners and cargo owners to take advantage of opportunity, which can arise out of uncertainty, and that inherently makes it a natural partner, which is actually quite an exciting place to be in a world, as you rightly highlight, James, I suppose, is likely to become more fragmented in the short to medium term. We are likely to see the shipping industry being used as a tool to enforce foreign policy objectives from jurisdictions, and that will rise naturally to a greater use of unilateral sanctions, not just against Russia, but against other jurisdictions, and also non-state actors, as we've seen with the recent sanctions against vessels supporting Houthi rebels, and in that context, I suppose, of what we are likely to see in the short to medium term, there seems to be consensus across the panel that English law, English dispute resolution, whilst nothing is perfect, is well placed to continue serving the needs of the shipping industry. And on that note, I think I'd like to thank my panelists very much for taking their time on this lovely sunny day to impart their knowledge and their thoughts to the audience, and wish you all a very good rest of the day. Thank you.